Bott & Co Solicitors Ltd, Appellant, and Ryanair DAC, Respondent.
The judgment will be handed down by Lord Burrows.
This is an important case for airline passengers, solicitors, and access to justice. It concerns fixed sums of compensation, the amount depending on the flight distance, that are payable to passengers for flight cancellations and delays under an EU regulation, Regulation 261. The same scheme continues to apply post-Brexit because Regulation 261 is retained EU law. Although the sums recoverable are relatively small, Bott & Co Solicitors Ltd, which specialises in consumer claims conducted on a no-win, no-fee basis, developed a business model whereby they could assist passengers to obtain the compensation to which they were entitled from an airline by taking on a large volume of claims. So this was a low-value, high-volume business model. Bott began handling flight delay compensation claims in February 2013. When this action was begun in October 2016, Bott had handled approximately 125,000 flight compensation claims. The business model was dependent on Bott first being paid its client's compensation by the airline, from which it could deduct the costs, that is the fees, agreed with its client before accounting across to the client for the balance. At the centre of this business model was what lawyers refer to as an equitable lien. This operates as a form of charge over the fund of compensation, and provided the third party, here Ryanair, has notice of it, the equitable lien gives security that the solicitor is paid its costs. In March 2014, Ryanair introduced a new process enabling customers to claim flight compensation using an online form available on Ryanair's website. Until early 2016, when it received a letter of claim from Bott, Ryanair dealt with Bott. When claims were admitted, Ryanair would pay the compensation into Bott's client account. From early 2016, however, Ryanair changed its practice. It sought to cut out Bott by communicating directly with Bott's clients and paying compensation directly to them. In October 2016, Bott commenced proceedings against Ryanair, seeking an injunction to restrain Ryanair from making any payment of flight compensation to a client other than through Bott's nominated client account, when on notice that Bott had been retained by a client. In addition, where since 22nd of September 2016, payments have been made by Ryanair directly to Bott's clients in such cases, Bott claims an indemnity for the costs which it's not been able to recover from its clients. Ryanair denies that Bott has the equitable lien justifying that injunction and indemnity. The judge at first instance decided that Bott did not have the equitable lien alleged, and that decision was upheld by the Court of Appeal. Bott now appeals to the Supreme Court. The Supreme Court, by a 3-2 majority, allows Bott's appeal. It holds that Bott does have the equitable lien alleged. The three justices in the majority, myself, Lady Arden and Lord Briggs, give separate judgments explaining our reasoning. The two dissenting justices, Lord Leggett and Lady Rose, give a single joint dissenting judgment. In my judgment, I explain that the leading case on a solicitor's equitable lien is the Supreme Court's 2018 decision in Gavin Edmondson Solicitors against Haven Insurance Company Limited, which were concerned with personal injury claims rather than claims for flight delay compensation. There, the solicitor had entered the relevant claim on an online portal in line with the pre-action protocol for low-value personal injury claims. the Supreme Court decided that in line with the promotion of access to justice, the solicitor was entitled to an equitable lien over the settlement fund because the solicitor's work had significantly contributed to the settlement of the client's personal injury claim. The Gavin Edmondson case may be regarded as updating the role of the solicitor's equitable lien in recognition of the modern approach to litigation and dispute resolution. And as I explain in my judgment, it's my view that the facts of that case cannot be satisfactorily distinguished from the facts of this case. I argue that the best interpretation of Gavin Edmondson, assuming that the solicitor is acting for a potential claimant rather than a potential defendant, is that it laid down the following test for a solicitor's equitable lien. Has the solicitor provided services within the scope of the retainer with its client in relation to the making of a client's claim, with or without legal proceedings, which have significantly contributed to the successful recovery of a fund by the client? If the answer to that is yes, the solicitor is entitled to an equitable lien over the fund for its costs. In my judgment, I reject an alternative, narrower approach favoured by the minority dissenting justices, focusing on whether there was a dispute or an anticipated dispute between the parties, and I point out that there was no dispute in any realistic sense of the term in Gavin Edmondson. Applying the correct claim-based test to the facts of this case, I therefore conclude that Bott is entitled to the equitable lien claimed. Lady Arden and Lord Briggs agree that the test I adopt is the correct test to be applied in deciding whether a solicitor has an equitable lien. Lady Arden traces the development of the solicitor's equitable lien in the case law and sees its animating principle since Gavin Edmondson as being effective access to justice. She points out that the 1917 case of Megaditchen and Lightbound, which has generally been interpreted as establishing a more restrictive rule for the availability of the equitable lien based on the issuing of proceedings, was partly overruled in Gavin Edmondson, but in any event should not be regarded as having established a firm rule. Like Lord Burrows, she firmly rejects any test based on whether there is a dispute or an anticipated dispute. Lord Briggs explains that while there is much common ground between the majority and minority judgments, including that the equitable lien promotes access to justice for potential claimants with insufficient means to pay lawyers up front, and that the equitable lien does not extend to solicitors' transactional work, the issue which divides the court is whether it matters that there is an actual or reasonably anticipated dispute about the claim at the time when the solicitors agree to act. He explains that for Lady Arden and Lord Burrows, what matters is that the solicitors agree to act in furtherance of a claim. Lord Briggs agrees with them that neither the client nor the solicitors may know whether the claim will be disputed when the solicitors are asked to act. It may have to be researched and formulated in some detail before its presentation to the intended defendant will elicit whether it is disputed either as to liability or quantum. By that time, the solicitors may have expended considerable time, effort, and even money in the form of disbursements on credit. Ultimately, Lord Briggs prefers the claim-based test adopted by Lord Burrows and agreed with by Lady Arden because it has the commanding advantage of simplicity and predictability. The dissenting judges, Lord Leggett and Lady Rose, consider that the claim-based test goes too far and that the correct narrower test for a solicitor's equitable lien is whether there is a dispute or reasonably anticipated dispute between the parties. That test, they argue, is a natural development from the old trigger laid down in Megaditchen and Lightbound, as to whether proceedings, whether in court or arbitration, have been issued. Applying the narrower test, there was on the facts, according to the dissenting judges, no dispute or reasonably anticipated dispute about Ryanair paying the compensation claimed, and Bott therefore was not entitled to an equitable lien. The dissenting judges would therefore have dismissed the appeal, but the majority, as I have said, allows Bott's appeal, and that is therefore the decision of the Supreme Court.
The court will now adjourn.